We will hear argument this morning in Case 24A884, Trump versus CASA Incorporated, and the consolidated cases. General Sauer.
Mr. Chief Justice, and may it please the Court. On January 20th, 2025, President Trump issued Executive Order 14160, protecting the meaning and value of American citizenship. This order reflects the original meaning of the 14th Amendment, which guaranteed citizenship to the children of former slaves, not to illegal aliens or temporary visitors. Multiple district courts promptly issued nationwide or universal injunctions blocking this order, and a cascade of such universal injunctions followed. Since January 20th, district courts have now issued 40 universal injunctions against the federal government, including 35 from the same 5 judicial districts. This is a bipartisan problem that has now spanned the last 5 presidential administrations. Universal injunctions exceed the judicial power granted in Article 3, which exists only to address the injury to the complaining party. They transgress the traditional bounds of equitable authority, and they create a host of practical problems. Such injunctions prevent the percolation of novel and difficult legal questions. They encourage rampant forum shopping. They require judges to make rushed, high-stakes, low-information decisions. They circumvent Rule 23 by offering all the benefits but none of the burdens of class certification. They operate asymmetrically, forcing the government to win everywhere while the plaintiffs can win anywhere. They invert the ordinary hierarchy of appellate review. They create the ongoing risk of conflicting judgments. They increase the pressures on this court's emergency docket. They create what Justice Powell described as repeated and essentially head-on confrontations between the life-tenured and representative branches of government. And they disrupt the Constitution's careful balancing of the separation of powers. I welcome the court's questions.
General Sauer, these universal injunctions, as you say, have proliferated over the last 3 decades or so. Would you discuss, though, the origins of universal injunctions? In particular, I'm interested in sort of historical analogs or the historical pedigree, particularly the Bill of Peace that was proffered by respondents.
Yes, Justice Thomas, as you, I think, first pointed out in your separate opinion in Trump against Hawaii, the Bill of Peace is something very distinct from a universal injunction. So the Bill of Peace involved a resolution of a small, discrete set of claims of a small, discrete group, and even more fundamentally, it was binding on the members of that class and those represented by the class. So it's much more analogous to a modern class action under Rule 23. And in fact, as we've argued in other cases, and as this court has described in opinions like Ortiz, the Bill of Peace evolved into and is directly developed into, so to speak, the modern class action that has all the same features of a Bill of Peace. So in the words of Chief Judge Sutton in the Sixth Circuit, the Bill of Peace, it was a domesticated animal that looks nothing like the dragon of a universal injunction.
I'm sorry.
Go ahead.
Here, there's a discrete identified group on one issue. Does citizenship mean are you born in the territory of the United States, or does it mean are you loyal to someone else, which is your claim, or are your parents loyal to someone else? So that's no different than what happened in a Bill of Peace. The United States is bigger, so it extends more broadly, but it's still an identifiable group on a discrete, singular question.
Your Honor, I'd say 3 things in response to that. First of all, our primary contention is that the citizenship clause related to the children of former slaves, not to illegal aliens who weren't even present as a discrete class at that time. But more fundamentally here, as to the issue of the Bill of Peace, there are critical differences. The Bill of Peace was a binding judgment that would bind absent class members. Here we have the asymmetry.
Well, here, class actions don't bind anyone who opts out, so class actions are not like bills of peace.
I would think that a Rule 23b2 class action, which would be the relevant analog here, would be one that would be binding on absent class members and would not have the same notice and opt-out procedures. And more fundamentally, that sort of argument that there's a commonality here among, all the people who purport to be affected by this is the sort of argument that's made in class certification.
So can
motions
I
which
ask
never
you a
presented.
question? Your theory here is arguing that Article 3 and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those. And they're
You argue
independent
both of
bases,
those?
Yeah.
If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide, but as
But
this
we
court,
couldn't enforce it against universally, is your argument.
if there was a decision that violated the precedent of the court, then the affected plaintiffs could get a separate judgment.
And
So
that
is what
means
this court,
you're talking about the hundreds and thousands of people who weren't part of the judgment of the court. They would all have to file individual actions?
not
Or-
necessarily, there
Or
are
a,
other,
or a class action?
a class action would be the way
Isn't
that,
that makes no sense whatsoever.
respectfully, we believe that.
Well, what was the purpose of the Bill of Peace if not to settle a legal question finally? And if even the Supreme Court doesn't have that right and must invite hundreds of thousands of lawsuits, what are we buying into?
If a set of claims satisfies the rigorous criteria of Rule 23, Rule 23 is the modern analog of a Bill of Peace. We have something very
So
different here.
no, we don't, because the argument here is that the president is violating not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign, doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here and were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen. So as far as I see it, this order violates 4 Supreme Court precedents.
Yeah,
And you are claiming that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally from violating those holdings by this court.
We are not claiming that because we're conceding that there could be an appropriate case.
Only a
Rule
class,
23
only
Can
by
I
a
hear
class.
can I hear the rest of his answer?
a Rule 23 class action. And then the more fundamental point as to all those Supreme Court decisions you referred to.
So what do we do temporarily?
Temporarily, the court may issue, the lower courts may issue injunctions that remediate the injuries to the plaintiffs that appear before them. Lower courts, in appropriate cases, may certify
So
class
when
action.
a new president orders that because there's so much gun violence going on in the country, and he comes in and he says, I have the right to take away the guns from everyone, then and he sends out the military to seize everyone's guns. We and the courts have to sit back and wait until every named plaintiff or every plaintiff whose gun is taken comes into court.
In appropriate cases, courts have certified class actions on an emergency basis. We found at least 4 cases in recent years where that was done. But more fundamentally, we profoundly disagree with the characterization of the merits. This is now fully briefed in the Ninth Circuit in case number 25-807, where we describe how that characterization of the holding of Wong Kim Ark and the other decisions is profoundly incorrect. And
You
that is
still
the
have
big-
Counsel, could I ask you about a different type of case that has broader impact than on the particular claimant. Like a claimant who's alleging that the districting in a particular case has resulted in racial discrimination against him or her based on how the district is drawn. Now, a judicial decision about that one plaintiff would implicate the redistricting throughout the whole case, throughout the whole state. How does your theory address that situation?
That would be what you might call an indivisible remedy, where what the court is doing there by, for example, redrawing the district lines is, as this court said in Gill against Whitford, the only way to remediate the injury of voting in an unconstitutionally drawn district. That is similar to abatement of a public nuisance or, for example, in the school desegregation cases, where remediating the injury to the plaintiff before the court necessarily has collateral consequences to many others. Certain environmental cases might have a similar thing. For example, you stop the local plant from pouring water pollution into the water. That benefits the plaintiff. It happens to benefit a bunch of other people. Now, that's very different than what we have in these universal injunctions, where it is a divisible remedy. I mean, I point to the holding of the District of Massachusetts in this case, looking at the individual plaintiffs. That court said, well, obviously, I don't have to give a universal injunction to protect individuals other than the individual plaintiffs. They are given complete relief by an injunction that tells federal officials only to treat their children as citizens.
Why, I guess the question is, why does the law require that? I mean, I appreciate that a court could, in a divisible remedy kind of case, narrow in to the plaintiff, but you seem to be suggesting that Article 3 or Rule 23 or something requires that, and I guess I don't really understand it.
If I may offer two responses to that. In the Article 3 context, that is the principle announced in Worth against Selden, announced in Gill against Whitford, and Lewis against Casey, where this court has said again and again, what we do in the Article 3 context is grant remedy that is tailored to, grant remedies that are tailored to remove the injury to the complaining plaintiff. Sometimes they have even very broad collateral consequences, but in the Article 3 context, what the court has not done, and every time it's focused on this in National Treasuries Union, Employees Union, in the
But I guess I don't see why then the divisible remedies or indivisible remedies is an argument. I mean, if Article 3 is suggesting that the court has to focus in on the plaintiff only, then it would seem to me that that would be the power requirement across the board. I thought Article 3 was really about limiting the court's power with respect to jurisdiction, that we say the court has to determine whether or not there's subject matter jurisdiction over the issue and whether or not there's personal jurisdiction over the defendant. And once you have those things, the court can evaluate the merits of the legal issue and issue, especially in equity, appropriate relief. Now, I appreciate that there are some prudential concerns that the court considers, but it seems to me that in many, many, many circumstances, we have not required the court to limit their relief to the particular plaintiff as a matter of constitutional Article 3 requirement.
I disagree with that, and I'd offer a response both first as to Article 3 and then as to the scope of equitable authority. In the Article 3 context, this court said in Worth against Selden, for example, that the Article 3 judicial power exists only to redress the injury to the complaining parties. Again, in Gill against Whitford and Lewis against Casey.
All right, so let me give you a hypothetical. So suppose we have a manufacturing plant that unlawfully releases environmental toxins into the air, and we have a plaintiff who lives near the plant, brings a nuisance lawsuit and says they're being harmed by unlawful release. Your argument suggests that the judgment for the plaintiff has to narrow in on preventing, to the extent possible, preventing harm to the plaintiff. But it seems to me that that's not necessarily the case. You suggest with the Chief Justice in response to him that there can be incidental beneficiaries, that the court could say no more toxins if it's unlawful for the defendant to do that, correct?
Yes, we do.
So why, if your Article 3 principle is correct?
Because again, the Article 3 principle is remedying the injury to the plaintiff, or set of plaintiffs, could be many, who are before the court.
Right.
That has collateral consequences,
Counsel,
that could help.
let me ask you on that point, would one distinction be who's bound by the judgment? Like, I'm wondering whether if the plaintiff needs, you can only, I think Judge Strauss said in the Eighth Circuit when addressing this issue, you can't peel off part of a nuisance, so the whole thing has to be shut down. Could a neighbor sue affirmatively to hold the nuisance maker in contempt if he started to begin again the nuisance?
That's a great point. It would not be bounding on those collaterally benefited parties, so to speak. I don't want to call them parties because they're not parties before the court. And that, of course, highlights one of the deep problems with the universal.
But why isn't
Could you
that
do
the
that?
answer, though?
Could you do that now for the universal injunction? Could a plaintiff, for example, who has the protection of the universal injunction but was not named in the suit, bring a contempt action of the sort I just described?
They could not do that, but what they could do is run to any of 93 other judicial districts and bring their own lawsuit if the
No.
relief is
Under
denied.
the injunction as it stands, under the injunctions as they stand, could a non-named plaintiff who has the benefit of the universal injunction that's currently in place, could that plaintiff bring a contempt proceeding?
We would.
Or I guess I shouldn't call them a plaintiff. Could that non-party?
We would dispute that they would have the standing to do that because it goes to the heart of.
Well,
what the
no.
problem-
Let's see. Maybe I'm not being clear. Assume the universal injunction is good. Like, drop your argument right now.
Oh, I see. Yeah.
As they currently stand, could someone who is not named in the suit but a beneficiary bring a contempt proceeding?
I think that is what the respondents would certainly contend.
Do you concede that the plaintiffs could bring a Rule 23, like the individual plaintiffs?
We would dispute. I mean, we'd have to address the Rule 23 issues, kind of all the criteria as they
Okay,
came up.
but they could seek it. Okay, and then last
and they
question.
have done that in Western District of Washington. It's just never been briefed because they
Okay, just last question on this point. The states have a different kind of claim for financial harm, and they've pointed out that it would be very difficult to remedy that without some sort of broader relief. I know you contest their standing. I want you to assume that I think they have standing. Why wouldn't they be entitled to an injunction of the scope of the one that has currently been entered?
I would say two reasons. First of all, it's not necessary to provide complete relief to the plaintiffs. What we offered, for example, in the District of Massachusetts in the First Circuit was an injunction that would enjoin the federal officials and order them to treat the people who would otherwise be covered by the executive order as eligible for the services that result in the pocketbook injuries to the states. And there's really no response to that. That is obviously would fully remediate their injuries and does not require the injunction to be applied in all other 50 states. One state comes in and says, well, people are going to move across state lines. Therefore, we've got 21 states in this case who don't want this relief. Sorry, you've got to impose it on everybody because it has to be offered to this one particular state. So that's one response. The other response is this notion that the states have to be provided a complete relief because of interstate travel and patchwork. I think that's very effectively responded to by Chief Judge Sutton's opinion in the Second Circuit, where he says, this is a problem. If we adopt this logic, it justifies a universal injunction in every single case, and that can't be the case. The Fifth Circuit's recent DACA decision comes to the same conclusion.
What do you say, though, to the suggestion, General, that in this particular case, those patchwork problems for, frankly, the government, as well as for plaintiffs, justify broader relief?
As to the government, again, Chief Judge Sutton addressed that directly as well when he said that's the federal government's problem. In other words, the federal government, for example, in the First Circuit, we offered that as a narrower scope of injunction, and the decision was, well, that would cause you too many administrative problems. And I think Chief Judge Sutton directly addresses that when he says that's a problem for the executive branch in the first instance.
All right.
Yeah.
And then with respect to class certification, your friends on the other side point out that that takes time. And there are, as you've emphasized, hurdles that have to be met to achieve class certification. And the argument, of course, is that the injury is immediate and ongoing, and as Justice Sotomayor suggested, might be seriously questioned as to its compliance with this court's precedents. Your thoughts?
I would offer a couple of things in response to that. First of all, there are tools for the courts have tools to achieve sort of class-wide universal relief. I referred earlier that we found 4 recent district court decisions where class-wide relief was given a kind of an emergency basis. However, more fundamentally than that.
And you agree that that's appropriate in certain cases?
It may be appropriate. We do not concede that it's appropriate in this case, but it may be appropriate in other cases. Certainly, it's an equitable tool that is consistent with, for example, the grant of equitable authority in the 1789 Judiciary Act, as this court interpreted in the Grupo Mexicano decision, and honestly, a line of decisions going all the way back to the early 19th century. So there are tools to address emergency situations, but more fundamentally than that, it is a feature, not a bug, of Article 3 that courts grant relief to the people who sue in front of them. So the notion that relief has to be given to the whole world because others who have not taken the time to sue are not before the courts is something that results in all these problems.
Last question. Do we need to reach the Article 3 question? I mean, wouldn't it be wise, even if you were to prevail, for the court to reserve that question rather than decide that Congress, for example, could never endow this court with that authority?
That's exactly correct. The court does not have to rest on Article 3 because the court could say, and as we've argued, and as Justice Thomas' separate opinion in Trump against Hawaii says, the 1789 Judiciary Act, when it said suits in equity are what the federal courts can do, we had nothing like this in mind. And that I point to the language in Grupo Mexicano where the court said there what was at issue was a preliminary injunction that froze and likely insolvent debtors' assets so that the plaintiff could collect at the end of the case. And the court said that's a nuclear weapon in the law, and we're not, that had no analog in 1789 in the practices of the Court of Chancery. And if that's a nuclear weapon, I don't know what this is, where repeatedly, 40 times in this administration, we're being enjoined against the entire world.
I'm just going to ask you to put yourself in a different frame of mind. Hard to do. Assume something you won't want to assume. But the assumption that I want you to make is that on the merits, which of course you did not take to this court, on the merits, you are wrong, that the EO is unlawful. And I want to ask you, if we assume that, how do we get to that result on your view of the rules?
It is very difficult for me to attempt the hypothetical, but I will.
You know, I think that that's the important question in this case. Let's just assume you're dead wrong. How do we get to that result? Does every single person that is affected by this EO have to bring their own suit? Are there alternatives? How long does it take? How do we get to the result that there is a single rule of citizenship that is the rule that we've historically applied rather than the rule that the EO would have us do?
Rule 23 would be one natural path, assuming that a class could be certified, which we might dispute in this particular case.
Well, you might dispute it, and you know, I mean, I think the question is there a class that's just all children of people who have entered illegally? You know, is that an appropriate